Kindly see, an end to the authorities engineer letter cited at reference number 1 in MDU review meeting held on 1/2/23, it has been instructed to EPC contractor, that is petitioner, to complete 5 kilometers of DBM by the end of this month. The same was assured at your end. So effectively it means up to 31/3/23 it was extended. Now, my lord, subsequently when we wanted to know when the recommendation was for 4/7/23, why it was cut short by 4 months, then we could lay our hands to the resolution of the board of meeting of the NHIDCL, where from lordships will find this agenda was not even considered. Now, my lord will kindly come to page number 170, 177. Sorry, 177 of the affidavit in opposition.
Page number
170 of the affidavit in opposition. It is 170.
wait, just a minute.
Yes, ma'am.
170.
Yes. Thank you.
170.
As a lord, my lord, minutes of the yes, 170 of the affidavit in opposition, minutes of the 78th meeting of the executive committee held on 6/3/23. As a lordship got it, my lord. Yes. Please come to 177.
Yes.
My lord will kindly come to 177 on top. Agenda number 78.22. It refers to our work. Kindly see, my lord, decision agenda was withdrawn.
The agenda was withdrawn.
Then on what basis the decision was taken to give only for up to 31/3/2023? The recommendation of the authorities engineer was up to 14/7/2023. That means, my lord, this agenda was not even discussed in the board meeting. They have perfunctorily done it. Now, my lord will kindly come to the impugned order at page number 32 of the writ petition. Page 32. This is on 15/3/23.
15.3.
Construction of 2-lane so-and-so on so-and-so termination order. After narrating all these things, my lord, the operative portion is at page number 43. Sorry, 42.
Yes.
Operative portion is at page 42, paragraph 9, towards the bottom. In the light of the EPC contractors' aforesaid contractual defaults, breaches, and willful non-performance as well as non-compliance of various notices and instruction of the authority engineers in writing and failure to achieve the progress committed by so and so, The authority is left with no other option but to terminate this contract agreement in accordance with clause so and so, so and so, so and so. Now, my lord will kindly take note of 2-3 dates, my lord. The third extension is dated 3rd of March 23.
Mm.
It is up to 31/3/23.
Mm.
The authorities engineer's recommendation, which I referred, my lord, at page number 273, on 14/12/22, they recommended that it should be extended up to 4/7/2023.
Mm.
Now, my lord, on 15/3/23, when the 78th meeting was held, there the agenda was not even discussed. So, my lord, how is it not a case where our case has not been dealt with fairly? Don't we have a legitimate expectation that our case should be dealt with fairly? Now, in any case, on 15/3/23, when they terminated the contract, we still had, my lord, 16 more days left because third extension was up to 31/3/23. So this is how, my lord, my rights have been dealt with. Now, my lord, just to show some of the contract law, these are the facts in nutshell. Now, my lord will kindly take the writ petition. I'll refer to few clauses to show where from my right flows.
Page number?
My lord will kindly come to page number 67. Kindly
Yes.
see, my lord, authorities engineer. Has your lordship seen it, my lord? On top, 1, 2, 3, 4, 5. Authorities engineer.
Mm.
Authorities engineer shall have the meaning set forth in clause 18.1.
Select the
Now, my
meaning.
lord will kindly come to page 151.
151.
Yes. Because they recommended that my extension should be up to 4/7/23.
Mm.
Authorities shall appoint a firm of consulting engineer or project monitoring committee, PMC, substantial in accordance with the selection criteria set forth in Schedule and to be engineer under this agreement, that is authorities engineer. Then my lord will kindly come to 18.2, duties and authority of the authorities engineer.
Yes.
Kindly see, my lord. Authorities engineer shall perform the duties and exercise the authority in accordance with the provisions of this agreement and substantially in accordance with the reference set forth in Annexure 1 of Schedule N, but subject to obtaining prior written approval of the authority before determining one extension of time, amongst others, my lord. So, authorities engineer has right to recommend for extension of time subject to approval by the authority. So that is how, my lord, by that, my lord, the page 14/12/22 order at page 273, extension
200?
was recommended up page
Yes.
273, my lord.
Ah.
Page 273.
Mm.
If your lordship would kindly come to 276.
273.
It starts at 273 and it ends at, my lord, 276.
Yes.
Kindly see, my lord, last sentence.
Mm.
Therefore, in view of the above mentioned fact, it is requested to consider the above proposal for extension of time EOT 3 up to 4/7/23. So this was never considered because in the meeting at the page 170 of the affidavit in opposition, which I have shown, the agenda was withdrawn. So, my lord, we never got a fair consideration. Then, my lord, will kindly come to page number 72. Page 72. Right of way towards the bottom, my lord. Right of way. Right of way means and refers to the total land required and acquired for the project, both in its width and length, together with all ways, leaves, easement, unrestricted access, and other rights of way, howsoever described, necessary for construction and maintenance of the project highway in accordance with this agreement. Then my lord will kindly come to the next page, page 73. Kindly come to this towards the bottom, time extension.
Yes. Right.
Time extension shall have the meaning set forth in clause 10.05. That is, my lord, may kindly make a note, page 123.
Mm.
123, 10.5.
Mm.
Without prejudice to any other provisions of this agreement for and in respect of extension of time, the contractor shall be entitled to extension of time in the project completion schedule to the extent that the completion of any milestone is or will be delayed by any of the following, namely, kindly see, my lord, delay in providing right of way of construction zone, etc., etc. In this case, my lord, we are concerned with C, occurrence of force majeure event, that is COVID-19, 1 and 2. Then, my lord, D will come into play. Any delay, impediment, or prevention caused by or attributable to authority, authorities personnel, or authorities other contractors on the site. E, any other cause or delay which entitles contractor to time extension in accordance with the provisions of this agreement. So, my lord, in my humble submission, what follows from this clause is the contractor has a vested right to get settlement. Of course, my lord, we must justify, we must show how we are entitled to, on what account delay caused. So the letter dated, my lord, at page 273, which I have shown, as regards the third extension is concerned, that authorities engineer has clearly laid down. So it is not my version. It is the project monitoring authorities version that I am entitled to extension up to 4723, which was never considered. Then my lord will kindly come to page number 53, my lord. Force majeure and termination, 21. Kindly come to 21.6 at page 53.
53.
My lord.
Mm. Mm. Part 5.
Effect of 21.6, my lord.
21 point.
Effect of force majeure event on the agreement. Effect of force majeure event on agreement 21.6.
Mm.
My
Yes.
lord, may kindly take note of page 184 and 185 for the effect.
180, 1.
4, 184 and 185.
Mm. Yes. 21.6.
Yes, my lord.
Mm.
Upon the occurrence of any force majeure after appointed date, the cost incurred and attributable to such event and directly relating to this agreement shall be allocated and paid as follows. Upon occurrence of a non-political event, parties shall bear their respective force majeure costs, and neither party shall be required to pay to the other party any cost. Upon occurrence of an indirect political event, all force majeure costs attributable to such indirect political event and not exceeding the insurance cover for such indirect political event shall be borne by the contractor, and to the extent of the force majeure cost exceed such insurance cover, one half of such excess amount shall be disbursed by authority to the anyway we are not concerned with A and B. C. Upon occurrence of political event, all force majeure costs attributable to such political shall be reimbursed by the authority to the contractor. For avoidance of doubt, force majeure costs may include costs directly attributable to the force majeure event, but shall not include debt repayment obligation, if any, of the contractor. Then my lord will kindly come to next page.
Mm.
3 on top. I am harping on this, my lord.
Yes.
Upon the occurrence of any force majeure event during construction period, the project completion schedule for and in respect of the affected work shall be extended on a day-or-day basis for such period as performance of contractor's obligation is affected on account of force majeure event or its subsisting effect. So I am relying on this method. On the happening of a force majeure
Well,
event,
sorry, page number 185.
yes, 3, Roman 3 on top, my lord.
Roman 3.
Two, 21.63.
185.
So, my lord, I am entitled to extension under this clause also because of occurrence of force majeure event.
Mm.
Now, my lord, Lordship has seen the facts. Lordship has seen the provisions contained in the agreement. It clearly says, in the event of force majeure event, the contractor is entitled to extension of time. If there is delay in giving my lord right of way, then also the contractor is entitled to extension. Now, my lord, first two extension we got. The third extension was recommended by the my lord authorities engineer, that is my lord that authority, project monitoring authority, and the matter was discussed in the meeting of the board on 15/3/23, on which date my lord that agenda was withdrawn. So as a result, nothing had happened. Therefore, my limited submission is, my lord, the impugn order of termination should be set aside and matter should be remanded to that authority to take a decision in accordance with the, my lord, I mean, the view, recommendation of the authorities engineer. That is my only limited prayer, my lord. Because I am entitled to a fair consideration. That fair consideration has been denied to me. This the termination order at 15.3 should be set aside, and there should be mandamus should be issued, my lord, to the authority to consider they consider the extension period as recommended by authorities engineer. This is my humble submission, my lord. Provided lordship feels that no, I would like to hear on merit, that's a different thing.
All
I think, my lord, this is the main thing, my lord.
Force majeure is your basic ground. Force majeure.
Force majeure, my force majeure and delay in handing over right of way.
Ah, yes, ROW is there. Hmm.
Yes, because the authorities engineer has already indicated. Well, they may reject, but they may reject with good reason. But they have not even considered. I have a right of consideration.
Hmm. Okay.
So that is my prayer at this stage, man.
If I may be allowed, Lordship. Lordship, in preferring this IA, Lordship,
Not
if I
on
can
IA,
go
on
with
the main
the
petition
on the
itself.
okay, Lordship, on the main
IA
petition,
same thing.
Lordship, I will also be brief in my submissions. Lordship, as the Learner Senior Council have already stated, this contract was executed and signed on 29/5/2020. That is not disputed. Joint memorandum has been executed on 22/6/2020. And then in the joint memorandum, the appointed date was fixed on 1/7/2020. Lordship. So the project was to be completed within 18 months. That is to say 549 days. Lordship. So as per the contract.
The problem is that contract, when the contract was valid,
Lordship.
you terminated the contract when there 64 days was left to be completed.
No, Lordship.
No, that is a document, na?
Lordship,
Page number 67, then 273, 273 see.
Lordship, as my response to this page number 273, that is the authorities engineer.
Delay in handing over of row, subsequent hindrances in the row and local issues.
If the Lordship is talking about page 273 of the writ petition, with regard to page 273 of the writ petition, Lordship, the authority engineer, herein he has a power to recommend, suggest, and even request the authority. The authority is the NHIDCL, is the respondent. He has the power to make recommendations, suggest, but the final authority lies with the ministry here, Lordship. And the authority, the engineer's authority, authorities engineer, sorry, Lordship.
Authority engineer is
Yes,
fine.
he's answerable to the MORT, Ministry of Road Transport and Highway. Lordship, if you come
Where are the recommendations? Authority engineer.
Lordship, if you can kindly turn to page 273 of the petition.
273. What was his recommendation? Last page, 276, I think.
No, not 273. I'm sorry, Lordship. Page 151. 151 of the writ petition.
151.
Here in 18.2, clause 18.2, duties and authority of the authorities engineer. The authorities engineer shall perform the duties and exercise the authority in accordance with the provision of this agreement and substantially in accordance with the term of reference or TOR, set forth in Annex 1 of Schedule N, but subject to obtaining prior written approval of the authority before determining. Lordship, it says, subject to obtaining prior written approval of the authorities.
Determining any time extension.
Yes, Lordship.
A.
So here, uh, when the opposite party is saying that the authority engineer has given its recommendation for extension of time, they have not received the prior information, written approval of the authority.
Who did not receive?
The authority engineer, in recommending the extension of time,
without the approval of the authority.
he does not have the authority. And here in the agreement, it clearly says, subject to obtaining prior written approval of the authority before determining EOT, extension of time. And when it comes to force majeure, in considering the force majeure as stated by the opposite learned council, senior council, the NHIDCL have granted extension of time 1 as well as extension of time 2 because of the force majeure, which is more or less due to the COVID situation, mainly due to the COVID-19 situation, as well as some other factors which may or may not have caused the delay. But in considering all those things, the NHIDCL has already granted extension of time 1 and extension of time 2. And then after even granting them extension of time 1 as well as extension of time 2, they are again coming with extension seeking on the recommendation of the authorities engineer. They are seeking for extension time 3 and 4. However, when this extension with regard to 03/03/2023, 3rd March 2023 was given for them to complete the next 5 kilometers of bitumen works for the next 5 kilometers till up to date 15 March. That is the day of termination of the contract. No bitumen work has been started or laid over. So seeing the progress, seeing the slow progress or the slow progress of work, the ministry did not find any merit, and hence the extension, hence the termination of contract was issued. But before giving this termination of this contract, cure notice under clause 23(1), subclause Roman letter 1. If your lordship can kindly follow. It's in page 189.
One 181.
189
189, page 189.
of the writ petition. Yeah.
Cure notice under clause 23(1), Roman 1 has been issued. If I may be allowed to read your lordship.
Page 189, na?
Page 189, termination. Page 189 of the writ petition, lordship. Clause 23(1), termination of contract default. Roman 1, subclause 1, C. The contractor does not achieve the latest outstanding project milestone due in accordance with the provision of Schedule J, subject to any time extension, and continues to be in default for 45 days. So, Lordship, as per this, cure notice has been served, already been served to the petitioner herein. Thereafter, notice for intention to terminate the contract has been issued on 16/1/2023. That is in page 191, Lordship, of the
Page number?
191. Notice for intention to terminate the contract has been served under this clause.
Yes.
Clause 23, 1, subclause 2, Roman 2. If I may be allowed to read, Lordship.
Termination.
Without prejudice to any other rights or remedy which the authority may have under this agreement. Upon occurrence of a contractor default, the authority shall be entitled to terminate this agreement by issuing a termination notice to the contractor, provided that before issuing the termination notice, the authority shall by a notice inform the contractor of its intention to issue such termination notice and grant 15 days to the contractor to make a representation, and may, after the expiry of such 15 days, whether or not it is in receipt of such representation, issue the termination notice. So, Your Lordship, intention to issue such termination notice has been served on 16 January 2023.
That is, Lordship, the intent termination notice is page number 243, annexure R11.
243.
Our reply affidavit.
Of the opposition.
Reply affidavit.
Yes, Lordship.
243.
3.
243.
Lordship, in order to save time, I'll directly go to the subject. Subject, construction of two lane with hard shoulder of Kohima Jesami Road on NH29 from existing kilometer 98.380 near Chisami village to existing kilometer 120.367 Nagaland Manipur border, design kilometer 95.700 to kilometer 117.200, design land 21.500 kilometer under Bharatmala Pariyojana on EPC mode package 5. Notice for intention to terminate to the EPC contractor under clause 23.
Your page number? Page number?
Page 243
243 of the affidavit.
of the affidavit in opposition.
243.
This is the intention, notice of intention to terminate, Lordship.
Due to slow progress and the
This is the notice for intention to terminate to the EPC contractor under the clause 23.1, subclause 2 of the contract agreement. And the references here from Roman letter 1 till up to the last references. All these references are the cure notice for slow progress, cure notice for not maintaining traffic worthy condition of the road, and so on and so forth, Lordship. All these are the cure notice which has been served over the course of time since the appointed date.
Participated projects, cycles, progress,
Page number.
progress, notice.
Lordship, if you can come to page 18. 18 of the reply in opposition.
18.
Yes, Lordship. Page 18 of the affidavit in opposition. Here in the table, in the chart, you can see the monthly progress in percentage. The first column is to do with the month. Second row is to do with the percentage of work program submitted by the contractor. And then the third row is the percentage of progress achieved by the contractor. So Lordship, here in this, by this chart, this table, it is very clear. For the month of March 2022, the percentage of work program submitted by the contractor was 13.59% of the total work. But the progress achieved was actually 1.54% only. Similarly, for the month of April, 12.12, achieve is only 0.83%, and so on and so forth. So because of all these reasons, the respondent herein, as well as the authorities engineer, they have served more than 25 cure notice for slow progress.
All right. The grounds for delay in the execution of the work has been explained by
Lordship,
the petitioner.
Lordship,
Did you consider the grounds for the delay effectively?
Yes, Lordship.
Lordship, we have,
Effectively, did you consider?
Lordship, we have, we are saying we have considered the delay,
Yes. Where is
and then
where that is mentioned? In
it can be
clear
seen in
details.
our extension of time 1 as well as extension of time 2. Para 10,
Para 10 or page number 41.
Yes, Lordship.
Huh?
para 10 will be page.
Page number 41 is the action times awarded approved by the headquarters.
Para 10 onwards, we have given our explanation that we have already
In
considered.
the affidavit.
Yes, Lordship.
Lordship, it is to do with our annexure R3. R3 will be in
Para 10.
para 10.
Para
And
10
then the,
has now achieved the progress as stipulated in the program work submitted by him.
So if the Lordship can kindly turn to page 41, annexure R3.
affidavit plus 42, na page number?
Page 41, Lordship,
41.
annexure R3.
41.
Lordship, if you can
What
kindly.
is this? This is 41?
This is the extension of time 1. The extension of time which have been considered by the respondent hearing. So, Lordship, if you can kindly come to the chart, to the table.
Thanks. All right. Next.
Page, clear table will be on page 43, Lordship. When it comes to milestone 1, 161 days has been revised and considered. When it comes to milestone 2, another 175 days has been considered. And when it comes to milestone 3, 175 days has been considered and revised. And also for milestone 4, another 175 days has been considered as well as revised. So, Lordship, here the respondent herein has considered the case of the petitioner for the delay which has been cited.
Okay.
Lordship, if I can kindly take you to page 135.
135. 135 of the petition.
No of the reply. Affidavit.
135. Yes, for the subject that the major was put up consideration of the 56 meeting of the executive is 135.
Particularly with respect to agenda 56.9, which will be in page 139, Lordship.
139.
Lordship, if I may be allowed to read. Construction of two lane with hard shoulder of Kohima Jesami Road on National Highway 29, all National Highway 150, from existing so-and-so to so-and-so. The state of Nagaland are under so-and-so on EPC mode package 4. Package 4.
Sorry, Your Lordship, the agenda is 56.5.
Fif-
Sorry, I beg your
I'm
pardon.
sorry,
56.5.
5.
56.5, sorry.
Sorry, Your Lordship.
My apologies, Your Lordship. 56.5, which is in page 138.
138.
138, the previous page.
56.5.
The agenda is more or less the same, but here it talks about the package 5, extension of time of project milestone regarding. The decision made has been is the executive committee deliberated on the agenda and observed that technical division's recommendation in para 4.3.1 subclause 2 and 4.3.1 subclause 4 and in para 5 subclause 1 and 5.2 are different, which need correction. And 2, COVID phase 1 fell during March, April 2020, July/August 2020. Para 5, clause 2, need correction. With above observation, Executive Committee approved extension of time of 351 days. Lordship, here it's almost amount to 1 year, 351 days without LD. Internal milestone may be suitably determined by the technical division. That's a decision taken in this agenda. So, Lordship, when it comes to consideration of this delay and even for the, giving them sufficient time for extension of time, all this has been considered by the respondent. But despite all this, respondent, there was slow progress of work. There was also question of the quality of work which has been submitted over the course of this contract. And then finally,
What were the grounds for this termination of the contract? Basic causes.
slow progress.
Slow progress, Your Lordship.
Lordship is
Slow progress.
Yes, Lordship.
slow progress of
Till
work.
15th of
And
March.
Slow progress of work.
yes, Lordship, and here the opposite senior counsel is arguing that time is not an essence in structural work.
See,
However,
when there is provision for extension of the time,
Lordship,
then essence, that time is not the essence of the contract. He said so.
Lordship, that's what. But regarding that, Lordship, here what they are asking by way of this repetition is a specific relief, Lordship. And then when we come under the specific relief act, especially under section 20A, read with section 41HA, special provision for contract relating to infrastructure project has been mentioned.
Maybe there,
Specific relief act, no.
I 41HA.
And Lordship, this is also the grounds we have taken for vacation of this interim stay order. So, Lordship, if I may be allowed to read section 20A of the specific relief act.
Section
Lordship, section 20A.
capital A.
Capital A, Lordship, yes. Lordship, under section 20A, special provisions for contract relating to infrastructure project. 1. No injunction shall be granted by a court in a suit under this act involving a contract relating to an infrastructure project specified in the schedule, where granting injunction would cause impediment or delay in the progress or completion of such infrastructure project. Lordship, special legislation has been made under section 41HA of the same act.
Today
If I
you
may-
are on the petition or on the IA?
No, Lordship, the contention of
Petition
both are similar.
Petition also.
similar.
If uh, if the honorable court feels that it should dispose of the IA first, that is also we have no objection regarding that, or even the main petition, the contention are more or less the same, Lordship. So, Lordship, if I may be allowed to read this section 41HA as well. Injunction when refused. Subclause HA. If it would impede or delay the progress or completion of any infrastructure project or interfere with the continued provision of relevant facility related thereto or services being the subject matter of such project, Lordship. So, Lordship, it's our humble submission before this honorable court to at least allow the respondent to open the technical bit as well as the financial bit as time is essence in this matter, Lordship. The final contract shall and can be opened or can be determined by after the outcome of this honorable court's decision. Lordship. No, my humble submission before this court is, Lordship, to at least allow us to open the financial technical bit as well as the financial bit, as time is the essence in this matter. Lordship, this NIT, notice inviting tender, this takes time to process. So in the meantime, if modification can be made in the interim order to allow us to open the financial bit as well as the technical bit, and then the final contract, as and when this honorable court give its final order, the contract can be amended as and when required. It will give us a contingency plan that a contractor or an EPC contractor can be readily be available as and when and this honorable court takes its judgment on that matter.
Okay. Yes, Sorori.
Lordship,
Yes, Sorori. Anything to reply?
My lord,
Specifically.
what I have understood from my learned friend, my lord, my learned friend, by referring to page 151 of the writ petition, he has contended that recommendation of the authorities engineer is subject to approval by the NHIDCL. That I agree, my lord. But my lord, it is some lords will kindly bear with me for some time, my lord. So, my lord, when an Supreme Court has said when an adjournment is granted, say on 1, 2, 3 day, then on 4th day also adjournment is granted, then Supreme Court says why adjournment was granted on first 3 days is not relevant. On 4th day, whether any case has been made out for grant of adjournment, that is relevant. Same principle or analogy if your lordships apply, there is no dispute that they have given first extension and second extension. They have in fact also given third extension, that is up to 31/3/23. Now, my lord, why on 15/3/23, when 16 days were left, they terminated the contract? They should have waited till, my lord, 31/3/23. That my learned friend has not answered. On the contrary, that page 273 recommendation of the authorities engineer, which recommended time up to 4/7/23, that was never considered by the board of directors of NHIDCL. They're bound to do it. They may reject it. If they have good reason, they may reject it. But the fact that the agenda was withdrawn, that means my case was not considered. Am I clear to Lordship's minor? That agenda item which was fixed for that 15/3/23 meeting, that they did not discuss. It was not taken to its logical end. It was just withdrawn. That means the recommendation of the authorities engineer, which recommended extension up to 4/7/23, that did not see the light of the day. So therefore, my lord, the decision-making process vitiates. My lord, with all respect, I will submit, in a 226 proceeding, lordship is concerned with the decision-making process, not with the merits of the decision. Whether I should get extension or not, that is an aspect which your lordships will not go into. The question is, if adjournment is refused on arbitrarily, then, my lord, that is an aspect which your lordships can go into. I cannot say, my lord, if some XYZ reason is given, if it is on the face of it arbitrarily, I certainly can say that this is bad on account of being arbitrary exercise. But if after taking note of all the relevant facts, extension is refused, then lordship will not sit in appeal over that. That is not the function of the 226 court. So what your lordship is concerned with is the decision-making process. Now, my lord, there is one more thing, serious infirmity is there, my lord. Kindly give me 1 minute time. Now, my learned friend says the contract was rightly terminated. Now, my lord will kindly come to page number 191 for a moment.
Of the petition.
Just take 5 minutes time, my lord. 191 of the
190,
writ petition. 1,
190, huh?
191,
191.
191. Yes.
Yes.
Kindly see, my lord. Without prejudice to any other rights or remedies which the authority may under this agreement, upon occurrence of a contractor's default, the authority shall be entitled to terminate this agreement by issuing a termination notice to the contractor, provided that before issuing the termination notice, the authority by notice inform the contractor of his intention to issue such a termination notice and grant 15 days time to the contractor to make any representation, may after expiry of 15 days, whether or not it is in receipt of such representation, issue the termination notice. My lord, in simple words, in terms of clause 23.2, before resorting to termination, there is a requirement of giving 15 days notice, a notice of intention to terminate. Am I clear, my lord?
Hmm.
So there is a requirement of giving a notice of intention to terminate of 15 days. Now, in this case, my lord,
Yes.
in this case, my lord, they in fact issued one intention to terminate notice on 16/1/23.
Hmm.
But my lord, what happened? On 2/3/23, they decided to give me the third extension. That means, my lord, they have waived their right. Am I clear to lordships, my lord?
Yes.
They gave us a notice of intention to terminate the notice on 16/1/23, which your lordships will find at page 243 of the affidavit in opposition. 243 of the affidavit in opposition. But my lord, after this notice of intention to terminate, they have given the third extension. Third extension lordships will get at page number 281. 281, my lord, of the writ petition.
281.
And then to the authorities, the engineer's letter cited at reference, a review meeting held on so and so. It has been instructed to the EPC contractor to complete 5 kilometers by the end of month, that is 31/3/23. That means, my lord, they have resigned from that notice of intention. So there is a waiver. So in law, my lord, what we know is waiver is an, my lord, intentional expression or desire to enforce a particular right. Now, my lord,
Okay.
now where is that notice of intention now after this work order? So that way also the termination is bad. So there is, as of before 15.3, so therefore my humble submission is, my lord, my learned friend referred to section 20A and 41H of this specific relief act. My lord, this is not a suit. This is a 226 proceeding, my lord. It's a constitutional power, my lord, where your lordship is not governed by any parliamentary statute. Lordship would recollect when Administrative Tribunal Act was amended, whereby right of the High Court was taken away because against the order of Central Administrative Tribunal, it was said that appeal would lie directly to the Supreme Court. Then, my lord, the cases were filed, which is L. Chandra Kumar's case, where Supreme Court says, my lord, power under 226 is a basic structure of the Constitution of India. If it is a basic structure of the Constitution of India, then it cannot be altered by any parliamentary legislation. Therefore, my lord, all these arguments will not hold good. In the ultimate analysis, all that we are saying is, my lord, authorities engineer recommend the third extension that they have not considered. Am I not entitled to that consideration, my lord? They may give, they may not give, it is up to them. But if they give, is well and good. If they don't give, they must cite good reasons, which they have not done. That's why, my lord, there is a statutory duty which is required to be performed by the authority, which they have not performed. Therefore, my lord, in the facts of the case, I have molded my relief to pray for a writ of mandamus by setting aside the termination order and directing the authority, my lord, to consider the authority representations, sorry, authorities engineers letter dated at page 273. That is my humble submission.
Okay. Lordship,
I'm deeply
My last
obliged.
submission, Lordship, kindly hear, Lordship. Kindly come to the page number 204 of the writ petition. It is the contract clause 26.1, Your Lordship. Two zero four, Your Lordship. Lordship, this contract is bound by the arbitration clause. That is, the EPC agreement is the essence of any. I'll read down the clause, Lordship. Any dispute, difference, or controversy of whatever nature, whomsoever arising under or out of a relation to this agreement between the party and so notified in writing by the other party to the other party, the dispute shall in first instance to be attempted to be resolved amicably in accordance with the conciliation procedure set forth in the schedule clause 26.2, Your Lordship. Your Lordship, thereafter the clause 26.3, Your Lordship, subpara 1. Any dispute which remain unresolved between the party through the mechanism available prescribed in the agreement, irrespective of any claim and value which has not been granted upon resettlement by the party, will be referred to the arbitration, Your Lordship. Lordship, they have not come with the proper channel, Your Lordship, because they have the alternate dispute resolution processes there. If they have the dispute with the competent authority, they must have gone through by this resolution process and thereafter this arbitration, Your Lordship. Lordship, in this regard, arbitration is a consensual process, and this main object of the arbitration is to obtain a fair resolution of dispute by the arbitration tribunal without any delay or cost. Your Lordship, in this regard, I would like to put one judgment of the Supreme Court, Uttar Pradesh Transmission versus CG Power. Your Lordship, I may be
Mark the paragraph.
paragraph 67, Your Lordship. I may be read to aloud. I may be read. Your Lordship, may I? It is well settled law that availability of alternate remedy does not prohibit the High Court from entering a writ petition in appropriate case. The High Court may enter a writ petition, nothing availability of alternate remedy, particularly where the writ petition seeks information of fundamental right, where there is a failure of principle of natural justice, where the impending order proceeding are wholly without jurisdiction. And the fourth one, the wires of the act is under challenge. Your Lordship. Your Lordship, if you see read this section 5 of the Arbitration Act, we say that nothing anything contained in any other law for the time being in force in matter governed by this board, no judicial authority shall intervene except where so provided in this part. Your Lordship, the minimal intervention of the judiciary, the arbitration is this main essence of whereby the minimal intervention of judiciary is required, Your Lordship. There is a arbitration clause, Your Lordship. They must proceed with the arbitration first if they have the claim, legitimate the if they are saying that extension of time was not granted, Your
You
Lordship.
want that the matter should be referred to arbitration.
Yeah, Lordship.
My lord, I would like to reply to that point, my lord. I'm also relying on the same para 67. Same paragraph 67, I am also relying because it's a case of violation of natural justice. Because I have a right of consideration which has been denied. Therefore, it also violates my fundamental right. And secondly, my lord, merely because there is an arbitration clause, there is no bar. My lord, 2011, 5 SCC 697. 2011, 5 SCC 697, paragraph 33 and 34. My lord, where the Honorable Apex Court had
Paragraph
said,
number,
I'm reading it, my
para?
lord. 2011, 5 SCC 697, para 33 and 34. My lord, may kindly come to para 33. Apart from the above, Para 33 at page 708. Page 708, my lord.
708.
Yes.
Yes.
Para 33 and 34. Apart from the above, even on the question of maintainability of the writ petition on account of arbitration clause included in the agreement between the parties, it is now well settled that an alternative remedy is not an absolute bar to invocation of the jurisdiction of the High Court or Supreme Court. That without exhausting a such alternative remedy, a writ would not be maintainable. Various decisions cited by Mr. Chakraborty would clearly indicate that constitutional powers vested in the High Court or the Supreme Court cannot be fettered by any alternative remedy available to the authorities. Injustice, wherever and wherever it takes place, has to be struck down as an anathema to the rule of law and provisions of our Constitution. We endorse the view of the High Court that notwithstanding provision relating to arbitration clause contained in the agreement, High Court was fully within its competence to entertain and dispose of the writ petition filed on behalf of the respondent company. We therefore see no reason to interfere with the views expressed by the High Court. My lord, end of the day, lordships exercises constitutional powers. It cannot be fettered by anything, my lord. My lord, even parliamentary legislation cannot take away lordship jurisdiction. And my learned friend is referring to a clause in the arbitration. How can it be, my lord? So, my lord, I am referring both the judgment and on the proposition, my lord, that delay is time is not the essence of the contract, my lord. Lordship may kindly take the citation 2022 2 SCC 2022 2 SCC 382. Yes. My lord will kindly come to paragraph 30. My lord will kindly come to paragraph 34. Lordship may kindly straightway come to para 35. It is now well settled that whether time is of essence in a contract has to be page 395, para 35.
Therefore, time is the essence of the contract.
My lord may kindly come to para 34 first. In order to consider the relevancy of time, conditions, obligations, we may observe some basic principle. Subject to the nature of the contract, general rule is that promisor is bound to complete the obligation by date of completion. That is subject to exception that the promisee is not entitled to liquidated damage if by his acts or omission he has prevented the promisor from completing the work by time. These general principles may be amended by express terms of the contract as stipulated in this case. That means, my lord, those general principles can be, my lord, limited by the express terms of the contract. Now, para 35. It is now well settled that whether time is of essence of the contract has to be called out from the reading of the entire contract as well as the surrounding circumstances. Merely an explicit clause may not be sufficient to make the time the essence of the contract. So, my lord, there cannot be any general proposition of law. It will depend upon the facts and circumstances of each case. So, my lord, therefore, will it be too much to think that in a contract which contains express conditions for extension of time, that time may not be an essence of the contract? That, my humble submission, is the principle deducible from this decision. Therefore, my lord, their plea that now it is barred by arbitration is not tenable. That is our humble submission. I'm deeply obliged, man.
And yeah. Hard both says hearing concludes judgment is okay.
Obliged, my lord.